Good day, attorney. Good day, classmates. In continuation to the discussion in Antichresis, still under Article 2132, Antichresis as a contract, and just like any other contract to be valid, it must have the following essential requisites. First, consent. Second, object. And cause. Consent. So consent refers to the meeting of the offer and the acceptance of the thing, and the parties to the contract must have the capacity to give consent. In Antichresis, it refers to the express arrangement wherein the debtor agrees or consent to transfer to his creditor the possession of his immovable from which he is to receive the fruits, provided that these fruits are imputed to the debt until the debt is paid in full. Object refers to the subject matter of the contract, and it must be certain. And in Antichresis, the subject matter refers to the real property. Question: is it required that the thing be delivered? No. In Antichresis, it is not required that the thing be delivered, since this is not a real contract, and delivery is not required for its perfection. However, the delivery is required only in order that the creditor may receive the fruits. Cause refers to the essential reason or purpose of the contract, and in Antichresis, the essential reason or purpose is the application of the fruits of the immovable property to first, the interest, if there is, and then second, to the principal of his credit. Question: is it required that the loan should earn interest in order that it can be guaranteed with the contract of Antichresis? No. In the case of Balicer versus Noble, it was held that it is not essential that the loan should earn interest in order that it can be guaranteed with the contract of Antichresis, because Antichresis is susceptible of guaranteeing all kinds of obligations, may it be pure or conditional. Now let's go to the right of the creditor. The creditor has the right to obtain the products of the immovable given to him. And in this part, it is important to note that what was obtained by the creditor is only the products of the immovable property and not the immovable property itself. Question: does it cover all the products of the encumbered property? Under Article 1306, yes, as a general rule, it normally covers all the fruits of the encumbered property. However, as an exemption, the parties is free to stipulate a contrary agreement. For the obligations of the creditor is obliged to apply the fruits of the immovable. In the application of the fruits of the immovable, it must be applied first to the interest of the risk and then to the principal credit. Second, the creditor must pay taxes and charges of the state. However, the parties may agree otherwise. Third, the creditor must bear the necessary expenses, which is limited only to the expenses for the preservation of the thing and for the necessary repairs. And lastly, the creditor is obliged to return the immovable to the debtor. However, this obligation only arises if the debt is totally paid. Now let's go to the comparison between Antichresis and that of a real mortgage. On the aspect of delivery to the creditor, yes, in Antichresis, the thing must be delivered by the debtor to the creditor. However, for the real mortgage, no, because the debtor usually retains the possession of the property. On the creation of real right, in Antichresis, no, it does not create real right because the creditor only acquires the right to the fruits of the thing but not to the property itself. However, for the real mortgage, this is not the case because it creates right over the real property. On the obligation to pay tax, as discussed earlier, in Antichresis, the creditor is obliged to pay for the tax of the state. However, for the real mortgage, the creditor has no such obligation. And lastly, for the subject matter of the contract, both in Antichresis and mortgage, the subject matter is the real property. That would be all for Article 2132 under the topic of Antichresis. The other articles for this topic will be discussed by the next reporter. Thank you.